My Honorable Justices, my name is Amahle Ngubane and I appear on behalf of the applicants with my co-counsel, JC Francis. For the next 8 minutes, I will be addressing the issue concerning the unconstitutionality of Section 6.3.4 of the Respondent's Pregnancy Policy. My co-counsel will then address the issue of the violation of the first applicant, which is Rose's right to privacy and unlawfulness of her suspension for 10 minutes. We respectfully reserve 2 minutes for rebuttal. In turning to my submission, we submit that Section 6.3.4 of the Respondent's Pregnancy Policy is unconstitutional on these following grounds. Firstly, it violates Section 9 of the Constitution. Secondly, it violates the right to dignity. Thirdly, it violates the right to privacy and the right to found a family. In turning to the first ground, which is the violation of Section 9. Section 9 of the Constitution provides that everyone has equal treatment before the law. Section 6.3.4 of the Respondent's Policy violates the rights on 2 grounds. Firstly, it discriminates against learners on the basis of gender. Secondly, it discriminates against learners on the basis of pregnancy. In turning to the first ground, we submit under Section 9, we submit that Section 6.3.4 of the Respondent's Policy unfairly discriminates against male learners because male learners in similar circumstances to the first applicants, which is Rose, would not be required to disclose the identities of the woman they impregnated so that these women could account to instances of sexual violence, coercion, or statutory rape. Accordingly, this shortfall would not be in the best interest of these children. On the grounds of pregnancy, this section also discriminates against learners on the basis of pregnancy, as the policy does not extend protection to vulnerable girls who are sexually violated but not yet pregnant. Based on these 2 grounds, we submit that the policy violates Section 9, subsection 3, and that discrimination is unfair. On the basis of dignity, the Respondent's Pregnancy Policy is unconstitutional as it violates Section 10 of the Constitution, which is the right to dignity, which states that everyone has an inherent right to have their dignity protected. As the first applicant is a student, she is likely to be judged when disclosing the identity of the father and stigmatized on dating an older man who in this case is a bus driver and being pregnant at a young age. In the case of Teddy Bear Clinic, Teddy Bear Clinic versus Minister of Justice, in paragraph 52 states that dignity recognizes the inherent worth of all individuals, including children, as members of our society, as well as the value of the choice they make. Teenage pregnancy is already deemed negative by society, and by instituting this legal process, hence prolonging the applicant's case, the respondents hence directly encourage her further stigmatization and further being judged by society.
Ms. Ngubane, the idea of having a policy to deal with pregnancy at school appears to, if one looks at the policy, directed towards providing counseling, protecting the learner who's pregnant, and if the person responsible for the pregnancy is also a learner, counseling that person. So is that not an objective that is positive in terms of learners' rights and in terms of their right to education?
As the court pleases, may Chief Justice please rephrase the question.
Okay, it seems that when one reads the policy, the idea behind the policy is to protect both learners if both of them were responsible for the pregnancy through counseling and not through their suspension. And this part of the policy that we're dealing with today relates to persons outside of the education system. So I'm trying to understand what is wrong with the policy if it has that objective. Do you follow my question? Yes.
As the court pleases, my Chief Justice, what is wrong with this policy in this instance? It's that it violates the rights of the learners in reference to dignity, as per Section 10 of the Constitution.
Could I just quickly ask, just in relation to that, perhaps it might be useful if you could assist us by pointing to which bits of the policy. Is it the whole policy that you say violates the dignity, or are there specific aspects of it that do? Thank you. You understand the question? Yes. Thank you.
As the court pleases, my justice, it is the whole policy, because in this instance, it forces the applicants to reveal the identity of the father, which then in this instance violates their privacy. When proceeding to privacy...
Sorry, Ms. Ngubane. Commissioner Gom, do you have a question?
Yes, my question would be, is it the policy that is unconstitutional, or isn't it the application perhaps of the policy that has been wrong, and therefore that is unconstitutional? Because if you look at the policy, it says that if the biological father is a person outside the system, he too should be subjected to judicial inquiry and action if there is a case to answer. It doesn't appear that there was a case to answer here on the grounds of coercion, sexual violence, and assault or statutory rape. So is it the policy that is the problem, or the application here of the policy, perhaps?
As the court pleases, we as counsel for the applicant submit that it is both the policy that is wrong and the application of the policy. Because in this case, the manner that the respondents infringed on the applicant's right to privacy, and it discriminates against the learner's rights. Okay. In relation to the right to found a family, we submit that Section 6.3.4 of the respondent's policy violates the right to privacy on the basis that it does not contain sufficient procedural safeguards to relate how the information relating the identity of the father should be processed. In instances such as this one, in instances such as the one in this case, nothing prevents the school from unduly disseminating information regarding the instance of a judicial inquiry with third parties. Particular to this case, this equally violates the right to found a family, as disseminating such information places the second applicant's job, which is SEMO, at risk, unduly so. If this court pleases, I will now hand over to my co-counsel to address the issue of privacy and suspicion.
Thank you, Ms. Ngubane. Ms. Francis?
As it pleases the court, I am Jessie Francis, and I will now further be elaborating on the applicant's case. The second applicant is on the basis that the respondent violated their right to privacy. Section 14 of the Constitution states that everyone has the right to privacy, which includes the right to not have their privacy or communications infringed. We submit that by the respondent going through Rose, the first applicant's personal conversations, is a direct violation of the first applicant's constitutional right to privacy on these three grounds. 1. Rose had a legitimate expectation of privacy through the counseling. 2. The processing of personal information was in contrary to Section 11, subsection 1, paragraph A of the POPI Act. And 3. There were in fact less restrictive means to acquire such information about the identity of the father. On the basis of expectation of privacy, the respondent unjustifiably violated Rose's expectation on privacy on the basis that, by leaving her personal phone, no one would have the right to go through it without her full consent. The actions of Ms. Moshapa, a member employed by the educational institution, amounted to an act of wrongful intrusion in the breach of Rose's expectation of privacy. In the court in Bernstein versus Bester, at paragraph 69, it states that held that the acts of wrongful intrusion includes the reading of private information, and in this aspect can be extended into our case. The respondent might submit that Ms. Moshapa's actions were justified because they pursued a legitimate public interest. We submit that an honest assessment of her intention when searching the cell phone displays that she was not acting in the public interest. Ms. Moshapa has a notable reputation in engaging in gossip. This was evident when she went through Rose's phone for the sole intention of satisfying her gossiping tendencies and not necessarily searching ideally for Samuel's
Sorry, Ms.
identity.
Francis, can I ask you briefly? So if Ms. Moshapa was not a gossiper, but had good intentions, would that make a difference?
No, that would not make a difference because it's still a clear breach on privacy as she went through the phone during a counseling session.
And then just a second question. Let's assume that Rose was not in a relationship with Samuel where they had mutual feelings for each other, but that she was in a relationship with an educator who forced her into this relationship. And she was reluctant to divulge this because the educator had promised her that she would fail. And the school suspected this. Would that make a difference? Because then the school would say, well, we're concerned about Rose, and that's the reason we went into her private messages in order to protect her, because she would never divulge this information. Would that make a difference to the lawfulness of the search?
As it pleases the court, we as counsel for the applicant would like to submit that if Rose had to partake in sexual relations with a teacher, which is in the basic education, it would still not justify the reason for violating her right to privacy, but we would understand the cause for concern of checking such information, but not through this means of violation.
Okay, thank you.
We would like to bring this Honourable Court's attention to the Poppy Act violation. The Protection of Personal Information Act states that you can only process information with the consent of the data subject, nor was it in line with Section 11, subsection 1A of the Poppy Act, in which only allows the processing of the information if it is in the legitimate interest of the data subject, but as previously confirmed, the core intention of the respondent was not in the best interest of the learner. Furthermore, according to the Poppy Act, personal information needs to be processed legally in a manner that does not oppose to the need for the right of privacy. In this case, the first applicant, being the data subject, has not given her free consent for Ms. Moshapa to go through her personal belongings. Therefore, we as the counsel for the applicant submit that this is a direct violation of her right to privacy. We submit that the respondent could have considered less restrictive means to acquire such information regarding
Counsel?
Samuel's identity.
Can I just ask a question? Is there a balancing exercise that perhaps needs to take place here? What if potentially, let's assume there had been coercion or some practice which constituted undue influence? Is there not a concern that other learners may be at risk, and that for this reason it's important for the school to find out the identity of the father?
Understand that the school's main objective, one of their main objectives, is to ensure the safety and protection of the children. However, the manner in which the counselling, we can improve the managing of the counselling by maybe sticking to the main objective of counselling, and maybe after mutual trust is built within the counselling session, they will be notified and notice clear stance of fear or objection to reveal their personal information. The first restrictive means would be the school could have consulted Rose's parents, as she stated that the parents were aware of the relationship and hence it was consensual. 2, contact the second applicant with regards to the suspension and the rumours, as he is an adult. 3, as well as the respondent sticking to the main objectives of providing fair and constructive counselling to eventually build a mutual spirit of respect, where she should freely state this information. With regards to suspension, In turning to our submissions,
Sorry,
the
Ms.
aspects...
Francis, may I just stop you for a moment? You say that the interactions were consensual, and Rose is below the age of 18. Can people below the age of 18 consent to sexual intercourse?
The age of consent in South Africa is 16, so yes,
Thank
she
you, Ms.
can.
Francis.
Rose was not
Maybe,
obligated...
Ms. Francis, when you're still there,
Sorry?
when you're still there, it would appear Rose became pregnant somewhere in November, and then only in January it was discovered that she's pregnant. In other words, it would appear she conceived when she was 16. We're dealing with a victim who is 17 years old, who it has been discovered she's pregnant. So she conceived somewhere before she became 17. What would be your response?
As it pleases the court, whereas the counsel for the applicant feel as though November is at the end of the academic school year, and since the date of birth of the applicant was not disclosed, we are not sure whether the child was conceived. Therefore, we submit that it was by the age of 16, the legal consent age, as it was towards the end of the academic school year.
So you're taking the facts as they're given, you're not glossing them or making any assumptions.
Yes, no assumptions.
Thank you.
The Denga School pregnancy policy only cites that the identity of the father must be paid close attention to, not that the identity of the father must be disclosed. Therefore, it was unlawful to suspend our applicant for alleged misconduct that was not in line with the Code of Conduct. As it pleases the court.
You may continue for another minute or so. Do you need another minute?
Yes, please.
Okay. You asked so nicely, I'll have to give it to you.
Okay. In the case of Head of Department versus Welcome High School, the court stated that in terms of Section 9.1 of the Schools Act, the school governing body's power to suspend a learner is limited to cases in which a learner is suspected of serious misconduct, and in respect of whom disciplinary proceedings are then contemplated. Through a disciplinary hearing, though a disciplinary hearing is pending, her actions cannot be considered as serious misconduct, as it was not in the policy to disclose this information initially. And based on these facts, the respondent violated Rose's right to freedom of association as well as a right to education, as a suspension was not in her best interests. The matric academic year as well as the FET phase consists of strenuous as well as heavy content with a small amount of time. Therefore, our applicant was required to catch up on all this information through an important time in her academic career. To summarize, the counsel of the applicant strongly believes that the respondent had no grounds to suspend or pry into the personal affairs of the student.
Ms. Francis, can I ask a question, please? There's a problem of pregnancy in that school. There are there's a high percentage of pregnancies. By having Rose pregnant at school, wouldn't that encourage other girl learners to feel free to not be careful and to know that they could still be at school under these circumstances?
As it pleases the court, the main objective of this policy is to ensure that all pregnant learners are able to obtain their education throughout their pregnancy. Therefore, we are saying that Rose's case in this instance is different to other cases as it was consensual.
Ms. Francis, are you about to wrap up or have you wrapped up?
Can I just do my prayers, please, Honourable Justices?
Sorry?
My prayers, call for prayers.
Okay.
The counsel for the applicant respectfully requests that this Honourable Court 1 to declare that the decision made by the High Court was incorrect, as Section 6.3.4 of the Denga School Pregnancy Policy is highly unconstitutional, and that the unlawful search of the applicant's cell phone and the decisions made with regard to the findings and processing of this information directly violates the applicant's right to privacy, as well as 2, to inevitably conclude that the acts taken by the respondent were inappropriate and unjust, which lead to the applicant's violation of freedom of association and education. Respectfully submitted. Counsel for the applicant. Thank you, Honourable Justices.
Thank you, Ms. Francis. Good. Are the respondents ready? Is it Ms. Mukandelere?
Greetings to the Honorable Bench. I am Advocate Muthapuli and this is my co-counsel, Advocate Boy. In the case between Rose Mudau and Samuel Muloko versus Denga High School, we are appearing on behalf of the respondents on this Honorable Court to bring forth to the House its largest capacity. My Justices, I will be using the first...
Counsel. I know you have limited time, but if you wanted to speak a bit slower, that would be fine, and we would take that into account in your time. I know you're worried about getting through the time. Okay. Good.
My Justices,
and relax. Don't worry. Today the cells are closed. It's Sunday, so no one's going to go into the cells.
My Justices, I will be using the first 10 minutes. My co-counsel will be using the next 10 minutes, which sum up to 20 minutes of our submission. Your Justices, counsel for the respondent submit that Section 6.3.4 of the Denga School Pregnancy Policy is constitutional. My second argument is that the search of the cell phone and processing of such information does not violate the learner's right to privacy in terms of the Constitution. My co-counsel will further submit that the school's decision to suspend Rose is constitutional and does not violate the learner's right to a basic education and freedom of association. Your Justices, counsels for the respondent submit that it is important to note that Section 6.3.4 of the Denga School Pregnancy Policy is identical to the Department of Basic Education on management and prevention of learner pregnancy in schools. And the Denga School Pregnancy Policy has a legislation proving that it is constitutional. My Justices, Section 6.3.4 of the Denga School Pregnancy Policy is in line and consistent with Section 28, subsection 2 of the Constitution, which states that the best interests of a child are of paramount importance in every matter concerning a child. My Justices, in CASU, this policy was legislated in terms of Section 8, subsection 1 of the South African Schools Act number 84 of 1996, which states that subject to this act and any applicable provincial law, a governing body of a public school must adopt a code of conduct. For the learners after consultation with learners, educators, and parents of the school. This section aims to have a positive impact and aim on children, and also aims to protect learners' rights. My Justices, before admission of learners into the schools, learners and parents have to sign a code of conduct. Counsels for the respondent submit that this gives assurance that Rose and her parents have read and signed the code of conduct and gives consent to complying with it. Furthermore, the Department of Basic Education on management and prevention of learner pregnancy in schools is justifiable as it was stipulated by the High Court, stating that the policy is justifiable in terms of the Constitution. Your Justices, if it pleases the Court, I would like to refer the Court's attention to Section 8, subsection 4 of the South African Schools Act number 84 of 1996, as it states that nothing in this Act exempts a learner from the obligations to comply with the code of conduct of the school by such learner. Justices, nothing in this Act...
Sorry, Ms. Mukandelele, I just want to check with you whether you're saying because the policy and the code of conduct is made in terms of a law, and because Rose and her parents read it and signed it, then that's the end of the matter. Is that your argument?
Can you please rephrase the question, my Justices?
Are you saying because this policy was made in terms of legislation, and because Rose and her parents read it and signed it, they're bound by it, and therefore they cannot complain about it?
My Justices, as the Court pleases, they cannot complain about it because Ms. Mashapa is a local parent, so she has the right. So she had the right to limit Rose's right to privacy because the limitation was justifiable, and the purpose of the limitation was to see if there is a case to answer on the grounds of coercion rape, or sexual violence.
May I follow up with you, counsel, on that? If somebody had raped her, then she wouldn't be the one that was breaking the code. So what violation of the code would she have, what would make it justifiable to breach her privacy, if you see what I mean? Because she didn't break any of the school's code of conduct rules.
As the court pleases, Rose Mudau violated section 6.3.4 Rose Mudau violated section 6.3.4 by not revealing the identity of her unborn child, and this request was in terms of section 6.3.4 of the Denga School Pregnancy Policy. As the court pleases.
Counsel?
Sorry, I think Judge Victor had a question, but I just wanted to ask okay, doesn't matter. And then Judge Kitley after that, okay.
Thank you, counsel. You seem very familiar with clause 6.3.4. I want to take you to the last part of that clause, where a person outside of the basic education system can be interrogated or questioned by the school board. What right does the school board have to question someone outside of the jurisdiction of the basic education system?
Can you please elaborate, Justice?
Right. The last part of Article 6.3.4, it says, and this is a constitutional attack on this clause, if you look at the last part, what right does the school board or the teachers have to question someone outside of the system? Like Samuel in this case was completely outside of the system. What is the right or the jurisdiction to question someone outside of the basic education system?
As the court pleases, we must bear in mind that Rose Mudau is a 17-year-old girl learner, and in South Africa, she is regarded as a minor. So when Ms. Masha, when the respondents questioned Samuel, they wanted to know if there is a case to answer on the grounds of sexual violence or rape, as Rose Mudau is still a minor. As the court pleases.
So you see, the question was that legally, what gives them the right to do that? So can a school principal, for example, school principal is not a police authority, for example. What gives the school the authority to question someone outside of the education system? Do you want to consider that? Because that I think was the question from Justice Victor.
As the court pleases, the respondents are Rose's legal guardian, so they had the right to do that. As the court pleases.
Okay, and then I'll come to you.
I know you've got limited time. I just wondered if you look at because the whole focus of your submission has been obviously around 6.3.4 of the policy. Where in that policy does it give the school the right to extract the identity of the biological father from Rose? Where in that policy can we read that she has agreed to give up that information when asked, and that if she doesn't, she's breached that policy? Do you understand my question?
I don't.
Let me give. What in the policy places an obligation on Rose to answer a question by the school as to who is the father?
As the court pleases, Section 6, we must bear in mind that Section 6.3.4 is identical to the Department of Basic Education on management.
And I'm asking you to look at that section and to tell me from looking at it, where does it say to Rose that you must tell us when we ask who the father is? If you look at how it's written.
Counsel,
On
maybe the judge is giving you a clue to look at the wording of the policy that you are defending and answer the question having looked at the actual policy. Do you want to do that? Do you have it?
That's fine.
Yeah.
Your Justices, as the court pleases, I'd like to refer the court's attention to Section 8, subsection 4 of the Code of Conduct of the South African Schools Act number 84 of 1996, which states that nothing in this act exempts a learner from obligations to comply with the Code of Conduct of the school attended by such learner. Justices, nothing in this act exempts a learner who is Rose from complying with the policy. My second submission is that the search of the cell phone and processing of such information does not violate the learner's right to privacy in terms of the Constitution. My Justices.
Okay. I think there were, okay, but I think there were two questions. Are you okay? Andre, Judge Gom?
Yes, thank you. Once again, if we look at 6.3.4 of the policy, and you say that that has been violated, it is difficult to understand how that has been violated, because it says that the identity of the biological father only come under consideration in certain instances, and that is where there's a case to answer on the grounds of coercion, sexual violence, and assault or statutory rape. Now, on the facts of this particular case, it doesn't appear that there's a case to answer on those grounds. So I still find it a bit difficult to understand how she has acted in contradiction to 6.3.4. Can you perhaps explain that a bit better?
Justices, can you please elaborate?
No, you indicate that she acted in contradiction with 6.3.4. She violated 6.3.4 of the school policy. But if you look at that provision, then it seems that the identity of the biological father only becomes important where there's a case to answer on the grounds of coercion, sexual violence, assault, or statutory rape. Now, on the facts of this particular case, these factors didn't seem to play a role. So why exactly are you saying that she actually violated 6.3.4 as the principal and the SGB are saying on which they based the decision to suspend her?
As the court pleases, Section 6.3.4 of the Denga School Pregnancy Policy states that if the biological father is a person outside the basic education system, he too should be subjected to a judicial inquiry and action if there is a case to answer on the grounds of coercion, sexual violence, assault, or statutory rape. Ms. Mashapa wanted to know if there is no case to. The respondents wanted to know if there is a case to answer on the grounds of sexual violence and coercion. That's the court pleases.
Okay, so your answer is that they had to invade a privacy and look into a phone to establish if there was a case to answer.
As the court pleases.
If one of those four grounds were satisfied, that was the purpose.
As the court pleases.
Okay. I'm not sure how much of time they say you have to stop it, but we've asked you quite a few questions. So if you want to take another minute or two to wind up.
As the court pleases, I mind. As the court pleases, the first applicant, who is Rose, was given a platform to reveal information that was going to help to ensure that the policy was followed. The search of Rose's personal cell phone was not a violation of her privacy, but rather there was a limitation, but rather there was a justifiable reason and purpose to the right of privacy, taking into consideration the limitation and its purpose in terms of Section 36, subsection 1, paragraph B, which is the importance of the purpose of the limitation. The purpose of this limitation was only to make sure if it is not sexual violence, rape, and coercion. The best interests of Rose are of paramount importance in every matter concerning a child, in terms of Section 28, subsection 2. Her best interest that she is not a victim of danger, like rape or sexual violence. Ms. Mashapa is a parent in loco. She has the primary consent to make decisions as a parent to a child in Rose's absence. Ms. Mashapa's actions was to make sure that the school is in awareness of Rose's father of her unborn child, as Rose has refused to disclose such information. Ms. Mashapa's actions were to make sure that Rose complied with the school pregnancy policy. I submit again, my justices, Rose is not exempt from complying with the policy. Can I take my leave?
Thank you, counsel.
As it pleases the court. Justices, I confirm my appearance on behalf of the respondent. We are brought here today by the applicant on argument that the school has acted unlawfully and that its actions were unconstitutional on the basis that they violated the applicant's rights to freedom of association and education in terms of the South African Constitution. We, as the counsel for the respondent, respectfully submit to this court that the school's decision to suspend the applicant was not unconstitutional and that it did not violate the applicant's rights to freedom of association and education in terms of the Constitution. Firstly, I'd like to bring the court's attention to Section 28, subsection 2 of the Constitution, which states that a child's best interests are of paramount importance in all matters concerning the child. Justices, we, as the counsel for the respondent, submit to this court that the school's decision to suspend the applicant was in her best interest. Now, my justices, I'd like to bring it to the court's attention that the best interest of a child in this case is not only limited to not suspending her, as the applicant's case suggests, but it also includes teaching her accountability, teaching her that with every action there is a consequence. Teaching children accountability helps to instill moral values of right or wrong even when there's no one watching. We submit to this court that Rose Modal's suspension was in her best interest as it taught her accountability and responsibility. Rose Modal failed to comply with the school policy and as a result she was suspended. We submit to this court that the applicant must be held accountable for her actions and that the school's decision did just that. Section 8, subsection 1 of the South African Schools Act number 84 of 1996 states that the school governing states that the governing body of a public school, that subject to any applicable provincial law, the governing body of a public school must adopt a code of conduct for the learners after consultation with the learners, the parents, and the educators of the school. Subsection 2 states that a code of conduct referred to in subsection 1 must be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and the maintenance of the quality of the learning process. And subsection...
Can I ask you this question? You're dealing with Rose's suspension, correct?
Yes, my justice.
Now, at the time that Rose had been suspended, the school had already acquired the information that Rose should have given them. According to you, correct? They'd acquired that information by going into her cell phone. So at the time of her suspension, whatever means were used, the information had been obtained, correct?
Justice, I did.
At the time she was suspended, the school knew the identity of the father, correct? They found that out. And they also knew that Rose was in a consensual relationship with Samuel, correct? They would have known that from looking at her phone.
My justice.
So was the suspension simply not vindictive and just to punish her? Because there was no need to get any more information. They got all the information that they needed. What do you say about that?
My justice, I submit to this court that the school had to suspend Rose Modal as she failed to comply with Section 6.3.4 of the Denga High School Pregnancy Policy. The section, Rose Modal is obliged to comply with the school policy as is stated by the Schools Act, and she failed to do so. Therefore, the school had to suspend her. As it pleases the court.
Could I ask follow-up question because it's about exactly what you're talking about. Do you have Section 9 of the Schools Act in front of you? It deals with suspension and expulsion from school, and it says, subject to this Act and any applicable provincial law, the governing body may, after a fair hearing, suspend a learner from attending the school. Did Rose have a hearing before her suspension?
My Justice, we submit to this court that the main purpose of a hearing is to let both sides of the story to be heard, to let Rose Mudau defend herself from the respondents. We submit to this court that Rose Mudau was given a fair chance to defend herself at the counseling session that the school organized for her, and at the intervention that was organized for her with Ms. Mashapa and the principal, where she was asked to disclose the identity of her unborn child's father, and she refused. We submit to this court that a hearing is equal to the counseling session and the intervention that were given to Rose Mudau. She was given a chance to state her side of the story. She was given a fair chance to defend herself, and she still refused to disclose the identity of her unborn child's father, as it pleases the court.
Counsel, Counsel, can I ask you this? We're talking now about a fair hearing. There's nothing to suggest that her parents were called to say that they know about the sexual relationship, they know that it's consensual. Would a fair hearing in a situation as serious as suspension include not only the person testifying or being counseled, but any other persons? Should a fair hearing allow other persons to come in and give their views so that a decision is taken on all the facts?
My Justices, we submit to this court that Rose Mudau's Educators Act and local parents of her, they have the responsibility of ensuring her safety and well-being when she's within the premises of the school. So we submit to this court that the counseling session and the intervention that were given to Rose were fair in the sense that the school, her educators, which are her primary guardians when she's within the premises of the school, were present, and that she was given a fair chance to defend herself, if it pleases the court. My Justices, subsection 4 of the South African Schools Act number 84 states that nothing in this act exempts a learner from the obligation to comply with the code of conduct of the school attended by such learner. The school governing body is empowered by the Schools Act to determine school policies. However, the implementation of such policies requires a buy-in from the parents, learners, and educators of the school, which there was in this case, which makes the Denga High School pregnancy policy enforceable, which essentially means that all learners of the school are obliged to comply with the policy. We submit to this court that Rose Mudau was obliged to comply with the school policy as is required, as is stated by the Schools Act, and she failed to do so, which resulted in her getting suspended from the school. My Justices, the purpose of a school policy is to create structure and functionality in schools, to make schools a productive and safe environment for the learners. Policies are implemented to help schools establish rules and to create standards of quality for learning and safety, as well as expectations and accountability. We submit to this court that the school acted in terms of law in relation to Section 8, subsection 1 by adopting and implementing the policy. However, Rose Mudau's failure to comply with the school policy threatened and disrupted the main purpose of the school policy, which is to ensure the well-being and the functionality of the school, and therefore she was suspended. According to Section 9, Roman Figure 2 of the Children's Act 38 of 2005, when determining the best interest of the child, you need to look at the nature of the personal relationship between the child and any other caregiver or person relevant in those circumstances. We submit to this court that when Rose Mudau is within the school premises, her educators are her caregivers, as I have stated before. Her educators act in local parentage of her. They have the responsibility to ensure her safety and well-being for as long as she's within the premises of the school.
Sorry, Counsel, can I just test the submission that you're making? You're almost suggesting that as long as she's on the school premises and involved in educational activity, her educators are her parents, in effect, does that mean that her biological parents or her legal parents then are excluded from any decisions that might be taken with regard to Rose's well-being?
No, my justice. What it means is that seeing as her educators are her caregivers when she's within the premises of the school, they have the rights. They were well within their rights to determine what Rose's best interests were at that point. They were well within their rights to determine and to take the decisions that they made at that point, if it pleases the court.
To the exclusion of their parents? Are you saying they were entitled to do that without establishing from Rose's parents what their views might be?
My justice, while we recognize the fact that Rose Mudal's parents could have been called to the school, we also want to submit to this court that we also like to remind this court that, as we previously submitted, Rose Mudal's educators are her caregivers when she's within the premises of the school. They have the legal obligation to ensure that she's safe and sound. So we submit to this court that the decision that they made was well within their right.
Could I just ask you this? How fair could it be to have the teachers, who are the ones and the principal who actually suspended her, took the decision to suspend, also at the same time to be expected to be her guardians? It's like being the prosecutor and the judge, isn't it?
My justices,
in your own case.
My justices, we'd like to submit to this court that even parents are both the prosecutors and the judges when raising their children. They have the responsibility of making sure that discipline is instilled on their children, and that is the part that the school and the educators played in this case. They had the responsibility of making sure that Rose Mudal understands the seriousness of the matter, and at the same time still receives disciplinary. At the same time, she still is disciplined for her failure to comply with the school policy, if it pleases the court.
Thank you. I think there are two more questions. Justice Variava and...
Thank you. Counsel, do you agree that pregnant learners also have a right to a basic education?
Yes, my justice.
So, by suspending the learner, are you not denying her her right to basic education?
No, my justice. I'd like to bring the court's attention to Section 36, subsection 1 of the Constitution, which states that the general requirements for the limitation of any right is that it may only be limited in terms of law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. We, as the counsel for the respondent, submit to this court that the limitation that Rose Mudal's rights were not violated but were instead limited due to a plausible and justifiable reason, her failure to comply with the school policy. My justices, we'd like to submit to this court that the limitation clause says that
Sorry, there's one more question for you.
There must be a limitation and...
Oh, sorry, are you still busy answering that question?
Yes, my justice.
My apologies.
There must be a link between a limitation and a purpose. We submit to this court that the limitation of the applicant's rights to education and freedom of association in this case completely promote the purpose of the limitation, which is to teach the applicant accountability. And we submit to this court that the purpose of the limitation in the applicant's case is legitimate and justifiable, if it pleases the court.
Thank you, Chief Justice. I think Justice Variava asked my main question, but there is a follow-up question based on your argument that you just made now. You've referred to limitations, and Section 36 talks about a law of general application being the instrument that's necessary in order to make provision for the limitation. Can you tell me which law that you are relying upon here to justify the limitation or to set out the limitation? Are you referring to the Code of Conduct? And can you tell me, would you say that that is a law of general application in this instance?
No, my justices, we're referring to Section 28 of Section 2, which talks about the best interest of the child. We submit to this court that Rose Mudal's the limitation to Rose Mudal's rights was in her best interest.
Despite the fact that it's taking her away from school and therefore interfering in her right to education.
My justices, we'd like to bring it forward to the court's attention that Rose Mudal was only suspended for 5 days. We submit to this court that the 5 days that the school suspended Rose Mudal from is not going to have a huge impact on her academic life. It's not going to make her fail, my justice. The 5 days that Rose Mudal was suspended from school was for the mere purpose of teaching her that with every action that she takes, there will be a consequence, to teach her that she must comply with the school policy as is required by the Schools Act, if it pleases the court.
Thank you, Counsel.
Thank you, Counsel. Thank you for your submissions. We also just heard that in those 5 days, Rose was unable to participate in the National School Moot competition. But maybe she comes here next year with a baby. Thank you for your submissions. You may...
My justices, I'd like to request 1 minute from this court to finish up my prayers. We, as the counsel for the respondent, respectfully and humbly pray for this court to firstly rule that all the actions that were taken in submission that we have brought forth were in the best interest of the child. Secondly, to declare that Section 6.3.4 of the Denga High School Pregnancy Policy is not unconstitutional. Thirdly, to declare that the search of the cell phone and the processing of the information retrieved from it do not violate the learner's rights to privacy in terms of the Constitution. Fourthly, to determine that the school's decision to suspend the applicant was not unconstitutional and that was in her best interest. And finally, to rule that the school's decision did not violate the applicant's rights to freedom of association and education in terms of the South African Constitution. If it pleases the court, I'd like to take my stand. I'd like to take my views.
Thank you, Counsel. Applicants in reply, 2 minutes each. Are you going first, Ms. Francis? Okay.
As it pleases the court, I would like to submit our rebuttal for the counsel of the applicant. Firstly, we'd like to state that the Code of Conduct does not state anywhere that the information of the father has to be disclosed. It just states that careful attention has to be paid to the identity of the father. Secondly, the actions of the respondent was not in the best interest of the child, as Ms. Mashapa was known to partake in gossip, and therefore we see this as satisfying her tendencies. Thirdly, we feel as if the hearing was not fair on the applicant's behalf. As stated by the respondent, she is a minor. Therefore, why was the parents not permitted or informed of this meeting?
Do you accept that there was a hearing at all?
There was no fair hearing at all.
There was no fair hearing, or there was no hearing?
There was a hearing, but not a fair official hearing.
Where was the hearing?
Justices. At the school in the principal's office.
Okay.
4, we can see the actions of the respondent as a direct abuse of power, as they disciplined the applicant on means whereas she was not in the wrong. The fifth we submit is that, are we to assume that one policy by a school, an unconstitutional policy, overrides 3 rights, as we feel as though these rights weren't just limited, they were restricted and violated. The last point we have for this is that the school was not acting in loco parentis as Ms. Mashapa was not acting in the best interest of the child. Respectfully submitted. Thank you, Honourable Justices.
May I just ask one question? The respondent argued that it was a justifiable limitation for them to gain access to her details on the cell phone regarding who the father was. What do you say about that?
We submit as the counsel for the applicant that the actions taken was a direct infringement of the invasion of privacy, as this was covered up as a means to counselling, yet Ms. Mashapa went behind the applicant's back to retrieve such information by going through her social media as well as personal conversations.
Thank you.
Good. Thank you, Ms. Francis. Ms. Ngubane? Okay, you covered. Oh, just one. Good. Thank you. Then we've considered, or we have heard all your submissions. We've also read your heads of argument. This is a difficult case, so we're not going to deliver an extempore judgment, but we'll adjourn for a few minutes to consider the submissions. All right.